Hi everyone, Bruce Debbing, the bike lawyer, here today to talk to you about an important topic that can have a significant effect on your claim for compensation should you be injured in a bike accident. What I'm talking about is something called subrogation. Sounds a little scary, doesn't it? Most of you have probably never heard of subrogation before now, but if you've been injured in a bike accident and your health insurance has paid for your medical treatment, it's important for you to learn something about it. Now, basically, subrogation means the ability of one party or entity to stand in the shoes of another. In personal injury law, subrogation can mean a number of different things, but the type of subrogation we'll discuss in this video concerns the right of your health insurance company to be paid back money out of your injury settlement to reimburse them for the money they paid out for your medical treatment. Got it? Your health insurer paid for your treatment, you settle your case with the at-fault party's insurance company, and your health insurer wants their money back from you. This is really important because every dollar that you have to pay back to your health insurance company out of your settlement is one less dollar that you get to keep as part of your compensation at the end of the day. Now, right about now, you may be thinking, wait a minute, you mean I have to pay my health insurance company back for the treatment they covered for my accident? Why would I have to do that? Isn't that why I pay premiums for health insurance in the first place? Well, the answer to that question, in other words, whether they have a valid subrogation lien on your settlement money, depends upon the type of health insurance that you have and the state in which you live. Many health insurance policies have these contractual provisions in the policy that say if you're injured by a third party, you're obligated to pay back your insurer for monies they spent on your treatment if and when you recover compensation from that third party, either through a settlement or from a court judgment should you win compensation in a lawsuit. In other words, you have to pay your health insurer back because you agreed to as part of the policy. After all, your health insurance policy is a contract between you and the insurer, and if you signed up for that policy and agreed to that provision, then you contracted to reimburse the company. How can you find out if you have this obligation? Well, one way is to take a look at what we call the SPD, or Summary Plan Description of your policy. Look for any section that talks about if you are hurt by a third party, etc. That is usually a tip-off that you may have agreed to such a provision. Let's discuss how this typically works in the real world. Let's say you've been injured in a bike wreck by a negligent driver. You hire an experienced, competent lawyer to represent you in seeking compensation for your injuries. Your lawyer advises you correctly to be diligent in seeking appropriate treatment for your injuries sustained in the crash, and to make sure that your medical providers have your health insurance information so that your health insurer dutifully processes your medical bills. Then, one day, you receive something in the mail from a company that tells you they're working for your health insurer, and they've been asked to collect some information about your injuries. Two of the bigger companies that do this, by the way, are called Optum and the Rawlings Company. They include a questionnaire with a letter which asks questions like, have you been injured in an accident? Were your injuries the fault of someone else? Are you seeking compensation from that person? Who's their auto insurer? What is the applicable policy and claim number? Are you represented by a lawyer? What is the lawyer's contact information? And so on and so forth. Now, what should you do? Well, you can fill it out and send it in, but let me suggest the better course of action is to turn the letter over to your attorney right away and let them handle the communications with that subrogation company. Why? Well, there are a number of reasons. First and most importantly, your lawyer can advise you, depending upon the state where you live and the language of your policy, whether your health insurance company actually has a legally enforceable right of subrogation against you. Just because they're sending you this letter doesn't mean they have a right to the money. If your lawyer is competent, he or she will carefully review the policy language to make sure it's enforceable, and will also consider the subrogation claim in the context of the applicable law of the jurisdiction where you live. Here in Virginia, where my offices are located, for example, our state takes a dim view of subrogation and has actually passed a statute outlawing it. Many other states have similar statutes that either outlaw it entirely or at least require the subrogation claims be reduced by certain percentages if the injured person is represented on a contingent fee by counsel, which is the way most personal injury lawyers work. Unfortunately, however, whether any state law outlawing or limiting subrogation claims can actually protect you depends upon a number of things. For example, if you're on active duty in the military or are a veteran and your medical treatment was paid for through TRICARE, then the federal government has an enforceable subrogation claim under a federal statute that overrides state statutes that may prohibit or limit subrogation. This is called the legal doctrine of preemption, which makes federal law superior to state law under certain circumstances. Similarly, if you are a federal employee and you get your health insurance through your federal employment, regardless of which plan you have selected, the health insurer's subrogation rights remain strong and enforceable, even if the state where you reside has laws that prohibit or limit subrogation rights generally. Again, this is the doctrine of preemption at work. The same is true if you're an older person receiving Medicare benefits, or if you are a person of limited resources and you obtain your health care through Medicaid. Both Medicare and Medicaid have very strong enforceable rights to be reimbursed from your compensation settlement for the amounts they paid out for your medical treatment, regardless of what state laws may say. Now, what if it turns out that your health insurer does have an enforceable subrogation claim against your settlement money? Does that mean you will end up with nothing in the end? Not at all. As you probably learned by now, though, subrogation claims are complicated and are best handled by your attorney. But know this, in every case, no matter how strong a subrogation claim may be, there's always an opportunity to try and negotiate a reduction in that claim. Every dollar of reduction that your lawyer can negotiate is a dollar that remains in your pocket at the end of the day. Please understand, everyone, that this video only scratches the surface of what is a very complicated topic. Many factors come into play, including the facts of your case, the jurisdiction where you live, who your health insurer is, and what the language of your health insurance plan provides. The main thing to remember, though, is that subrogation claims can be managed successfully with the help of a knowledgeable attorney who understands the law and the process. My name is Bruce Deming, and I'm the Bike Lawyer. I hope you have found the limited information about subrogation in this video helpful. For more information about your legal rights as a cyclist and for safe riding tips, check out my website at thebikelawyer.com. Thanks for watching, everyone, and please ride safe out there.